So without taking much of your time, may I introduce the first session today? And I will invite the moderator, Mr. John Bosco Bugingo, the managing partner, Fountain Advocates, here in Rwanda, to please welcome the panelists and introduce them. Thank you so much.
Good morning, everyone. It is a very good morning, I can see. And I can only pray that today is as amazing as yesterday. I wish it for all of us. To you all, ladies and gentlemen, dear participants, allow me to first wish KIAC once again happy and 10th anniversary. It is such an honor for me to moderate today's morning session with the topic, the 2022 revised ICSID Rules and Regulations. The ICSID rules are the most commonly used procedure rules in investor-state dispute settlement. They came into effect on July 1st, 2022. And to give it some context, we will be discussing, the amazing panelists here will be discussing the aim, the scope of the revised rules and regulations, as well as highlighting the key changes to inform the investment arbitration. With that, allow me to introduce our panelists, the three of them, one very distinguished gentleman and two amazing ladies. Aissatou Diop is a legal counsel at the International Center of Settlement of Investment Disputes, which she joined in 2008. At ICSID, Diop has served as secretary of the tribunal and secretary of the ad hoc, the committee in over 50 investor-state disputes that involve countries mostly in Africa, Eastern Europe, the Middle East, related to a variety of economic sectors and are brought under the ICSID Convention and arbitration rules, the ICSID Arbitration or Additional Facility rules, and UNCITRAL arbitration rules. She published articles on international investment arbitration and spoken on the topic of a number of international conferences. Prior to joining ICSID, Diop was an associate at a law firm in Washington, D.C., where she worked in the International Trade and Investment Arbitration Group. She holds a BA in History, Political Science from Jamestown University, an MA in African Studies and Political Science from Yale University, and a JD with a concentration on international law from Northwestern University. She's admitted to practice, currently inactive, if she can confirm, in the state of Illinois and the District of Columbia. She speaks 3 languages, could be more, Wolof, French, and English. Welcome, Diop. Our second distinguished lady, Dr. Randi Ayman. I don't know whether the pronunciation is right, but yes, Randi Ayman is a senior research fellow in the Development of International Law and Dispute Resolution at Max Planck Institute of Luxembourg. Before joining the institute, Randi was legal counsel for nearly 7 years at the International Center for Settlement of Investment Disputes in Washington, D.C. Prior to that, Randi worked at the international arbitration practice of the law firms Sherman and Sterling, LLP, and Eversheds, LLP, both in Paris, at Le Défenseur des Droits in Paris, and the United Nations World Tourism Organization in Madrid. She specializes in investor-state dispute settlement, public international law, treaty law, and state-to-state dispute resolution. She earned her PhD, you already heard me call her Dr. Randi, with the highest distinction from the University of Paris. I don't know how to pronounce this. Paris 1 Panthéon Sorbonne, je pense, for thesis on the denunciation and renegotiation of treaties. Randi is dual qualified in Egypt and France. She holds master's degrees in international law, a maîtrise in international business law, and licence en droit from Paris 1 Panthéon-Sorbonne, as well as an LLB from Cairo University. Randi serves as an independent tribunal secretary in investor state proceedings and provides consultancy in investment policies and dispute resolution. Randi serves, she has prepared and delivered numerous capacity building trainings on investment law and procedure to government officials, practitioners, and students. She also teaches a course on international investment dispute resolution at University of Paris de Panthéon-Assas. Welcome, Randi. And finally, our own bâtonnier emeritus, Julien Kavaruganda, is the founder and senior partner at K Solutions and Partners, a corporate law firm in Kigali, Rwanda. He has been practicing at the Brussels Bar Association before joining the Rwanda Bar Association. Julien is the immediate past president of the Rwanda Bar Association, an immediate past board council member of the East African Law Society and former board member of Bank of Kigali. He is the current vice chair of the Kigali International Arbitration Center, KIAC, board member at MTN Rwanda Limited. It's a telecom company, for those who don't know. Board member of Rwanda Finance Limited, that is Kigali International Financial Center driving vehicle, and a board member of the Commonwealth Lawyers Association. Julien has over 18 years of experience. His practice covers corporate and commercial law, inclusive of mergers and acquisitions, JVs, privatization, banking and finance, project finance, capital markets, arbitration, energy and natural resources, and infrastructure law. It could be more. He's also actively involved in several environmental and ecological issues in the local community here in Rwanda. Julien remains ranked in Band 1 since 2012 until today by the Chambers and Partners. He is considered as a market's most highly regarded figure. A clap for that later on. Comes soon. He advises his clients on the full complement of business law concerning corporate structuring and transactions, as well as finance, real estate, construction, energy-related matters. He has experience advising on arbitration proceedings, in addition to his non-contentious work advising international investors, international organizations, and embassies. You are all most welcome, dear panelists. I'll take my seat if you allow, and we cut through the discussions of the day. Thank you. This discussion will take 45 minutes, and we shall, of course, give the audience 15 minutes for Q&A. I'll start with the lady right on my right. Aissatou, if you may allow me to take on you first. Looking back for starters, could you briefly tell us what ICSID rules are all about and what might have triggered a revision of the same to have the recent 2022 version? While we're still at that, simultaneously, could you, just for the time's case, what are the key features of the 22 ICSID rules and regulations? Over to you.
Thank you. Thank you for that kind introduction. If you allow, I'll also go to the podium. Yeah.
Yes. Yes, please.
I want to start by thanking KIAC for the invitation. Thank you again for that kind introduction. This is my first time coming to Rwanda, and before coming I heard a lot of good things, but when I arrived I realized that everything I heard was an understatement. So I just want to say I'm so proud of Rwanda, and I'm so proud of KIAC and what you have accomplished here. And I'm speaking under my Senegalese hat. And as we say in Wolof, Chakaw Chakanam, which means upwards and onwards to KIAC on your anniversary. Now, I'm going to wear my ICSID hat and give you a special message from the ICSID Secretary General, Meg Kinnear, who also says that ICSID wishes KIAC a happy 10th year anniversary and congratulates KIAC on this milestone. We're very proud to have a cooperation agreement with you, and we look forward to working with you in the next decade. Now, I realize that there are many investment arbitration specialists in this room, but for the benefit of those who are less familiar with investment arbitration and less familiar with ICSID, I just wanted to start with a brief introduction to ICSID and the work that it does before we discuss the 2022 rules. ICSID was established with the entry into force of the ICSID Convention, or also known as the Washington Convention, on October 14th, 1966. And its primary purpose is to encourage and stimulate the flow of private international investment in order to foster economic growth. And the way it does this is by providing facilities which are impartial and away from any influence or interference by any government for the settlement of disputes that may arise from time to time in these kinds of relationships between investors and states. And these disputes are brought sometimes by investors against states, but they are also sometimes brought by states against investors, less so. So what does ICSID's work consist in? It consists in the administration of arbitration and conciliation cases under the convention, where the state party to the dispute and the state whose national is a party to the dispute are both ICSID member states. The work also consists in conciliation, arbitration, and fact-finding under a different set of rules known as the additional facility rules. And this is for cases that fall outside of the jurisdictional scope of the ICSID Convention. ICSID also acts as appointing authority and administers disputes under other sets of rules, such as the UNCITRAL rules. However, arbitration under the ICSID Convention constitutes 89.5% of ICSID's work, and arbitration under the additional facility rules constitutes 8.8% of our work. So this is the big chunk of what we do. And so I will focus on these for a while in talking about the amendments. Now, if we could go back, is that the first slide? I think you're way ahead of me. Yeah, I think that's the, yeah. So if you could stay there, I'll just give you, yes. So before the current amendment, so the 2022 amendments, ICSID rules were amended 3 times in 1984, 2003, and 2006. And these amendments are generally driven by lessons learned in the cases over time, best practices developed in the field, requests made by our member states, suggestions from practitioners, etc. And the 2022 amendments were no different. I want to clarify, though, that we're talking about amendments, but the convention, the treaty itself, has never been amended before. And in part, it's because amending the treaty requires a two-step process that's strenuous, because we would need to have a unanimous vote of all of ICSID's member states, which now are 158 states, with Angola having ratified the ICSID Convention just a week ago. Now I'm on this slide. This slide shows you the back. Yes. So this slide shows you the timeline of the amendments. The amendments, they started over 5.5 years ago, so in late 2016. And we went through extensive consultations with our member states, arbitrators, counsel, academics, other facility users. Randi here was my colleague at ICSID during this process, and she knows something about the intensity of the process over the years. The amended rules were approved by 85% of ICSID's member states on March 21, 2022, and they came into effect on July 1, 2022. And there are several objectives that the new rules are aimed to achieve. One was to address time and cost concerns, which were big concerns that have been expressed for some time. To offer a broader range of options for the settlement of investment disputes, increase transparency of the process. I think actually Dr. Onyema asked questions yesterday about the availability of information and data. So I'm sure she'll be happy with this, with these amendments. So to incorporate also best practices developed since 2006, so the last amendments, and to respond to ongoing discussion about reform of ISDS. Next slide. The text of the new rules is posted on the ICSID website, and it's searchable. It's in searchable format, and it will soon be available in hard copy. You will find now that we have 4 separate booklets. The blue book, which contains, is for convention cases, and it contains the ICSID convention, the report of the executive directors of the bank, the administrative and financial regulations, the institution rules, the conciliation rules, and the arbitration rules for ICSID convention cases. We also have the yellow book, which contains the additional facility rules, a brand new set of administrative and financial regulations dedicated to additional facility cases, as well as conciliation rules and arbitration rules for additional facility cases. We have a new booklet, which is green, which contains new mediation rules and administrative and financial regulations for those cases. And lastly, we have a red book, which the booklet is new, but those rules are not new. They have been updated. These are fact-finding rules and additional and administrative and financial regulations for fact-finding. In addition to this, we have published an updated schedule of fees. We heard about ICSID fees yesterday. So we have published an updated schedule of fees and an updated memorandum of fees. And these apply as of July 1. So any work done as of July 1, 2022. In terms of implementation of these rules, I would note that for convention arbitration and conciliation cases, the rules apply as of the date of consent. So what this means is that if consent is given in a treaty or in an investment law by the state, and as it usually happens, that consent is accepted with the filing of a request for arbitration, it is at that moment that consent is then perfected, or sometimes people say crystallizes. And so if that perfection then happened after July 1, then the new set of arbitration rules would apply to that case. And for contract cases, it may be different because the offer of consent is given and accepted in one and the same document. And so if that happened prior to July 1, then a case that's registered would still go under the 2006 rules because the date of consent was prior to July 1, to the new rules coming into effect. And if the contract was signed after July 1, then it would come under the new rules. This is for convention cases. Now, for all the other rules, additional facility cases, mediation cases, fact-finding cases, the new rules apply on a different basis. So this is as of the date of the registration of the request. That's when the new rules apply. So now I'm going to, next slide, I'm going to just put some of these changes on your radar just to give you an idea of what they are. So one of the key objectives of these amendments was to reduce time and cost of the proceedings, like I alluded to earlier. And you will see provisions throughout the rules that contribute to this goal. So some provisions reduce time and cost by encouraging proactivity on the part of arbitrators and parties. So, for example, new Rule 31 requires case management conferences to take place throughout the proceeding. And the aim is to identify uncontested facts, clarify and narrow issues in dispute, and just address any other procedural or substantive matter. And at least one of these is required, but there can be more. There is also a new Rule 46, which provides which provides a procedure to consolidate like cases and also or to coordinate specific aspects of cases that are parallel. Some provisions reduce time and cost by incorporating modern arbitration techniques. For example, now at ICSID, all documents are filed electronically only. So no more hard copies. This means requests for arbitrations are filed electronically, memorials are filed electronically, unless there are special circumstances that require hard copies. Another modern technique is that parties and arbitrators now have the option to hold any hearing or any session by video or by phone or by a hybrid method. Next slide. An important area where also time limits have been addressed is with respect to the issuance of decisions, orders, and awards. And in particular here, the time frames have been specified and they have been reduced. So a tribunal now is expected to render an award as soon as possible and within 240 days, so that's 8 months, after the last submission dealing with jurisdiction and or merits, so not cost submissions which come later. And under the 2006 rules, the time frame for the issuance of awards was 120 days following the closure of the proceeding, which could be extended by a further 60 days. And some of you may know that the fact that the date of closing the proceeding was not specified caused a lot of delay. So this has now been addressed. And under the 2022 rules, if a tribunal is not able to meet a specified time frame, it must inform the parties of the special circumstances which justify the delay, as well as the date when it expects to render its award. This is under Rule 12 now. And the center will closely track the progress, tribunal's work progress on its website. Next slide. Another aspect of the new rules is third-party funding. Third-party funding was an item that evoked some really different perspectives among delegates during the amendment process. And it's a provision that did not exist before in the rules. And under the ICSID rules, third-party funding is when funds are received either directly or indirectly by a claimant to pursue a claim or by a respondent to defend a claim. And those funds could be through a donation or grant or remuneration based on the outcome of a proceeding. So, and this rule is intended to avoid inadvertent conflicts of interest between third-party funders and arbitrators. And so when arbitrators signed their declarations, they have to indicate whether they have a conflict with a third-party funder. The obligation, though, that comes, the main obligation that comes under this rule, the third-party funding rule, is an obligation of disclosure. And it's and it is met when the party receiving third-party funding sends a notice, a written notice, to the Secretariat, basically giving the name and address of the third-party funder, and that's it. And if the third-party funder is a juridical person, they also have to, the party receiving the funds has to disclose the names of all those who own and or control the third-party funder as a juridical person. Next, we have the manifest lack of legal merit rule, and this is a rule that's important for states, and it allows them to raise an objection early in the process in order, and if they're successful, to obtain an early dismissal of the case before it reaches jurisdiction or merits. And this rule existed under the 2006 rules. What is new about it, it's been updated to reduce the time frames that are applicable, and also it is updated to clarify the fact that the objection can be raised not only with respect to merits, but also with respect to jurisdiction. Another aspect of this rule that is new is with respect to decisions on cost. Because now, if a respondent that normally brings this type of objection, if a respondent is entirely successful in getting the case dismissed early, meaning that the tribunal issues an award disposing of the entire case, then there is a presumption of cost in favor of the successful respondent. But this is only when the respondent is completely, entirely successful on the objection, not if it's successful in part and some of the claims move forward to jurisdiction or merits. Then we have security for costs, also a new rule. Under the 2006 rules, security for costs was treated as a provisional measure, which is recommended, not ordered, pursuant to Article 47 of the ICSID Convention. Under the 2022 rules, there is now a standalone Arbitration Rule 53, which is only for security for costs. And it is now separated from provisional measures. And it establishes the power of the tribunal to order, not recommend, security for costs. It provides the procedure specific to security for costs, including a time limit within which the tribunal is to issue its decision. It provides guidance on the circumstances to be considered by a tribunal based on ICSID case law. And these include the ability and willingness of a party against which security for costs is being sought to provide such security, as well as the effect that providing security for cost may have on the ability of that party to pursue its claim or its counterclaim. So we're talking about access to justice. Finally, the rule also provides consequences for non-compliance with an order for security for costs. And the consequences include suspension after a certain period of time, which can lead to discontinuance of the case. The rule, though, is permissive. It's not mandatory. And so the tribunal has discretion to take the circumstances of the individual case into account in deciding whether to proceed with suspension or whether to proceed with discontinuance in each particular case. I'm coming now to transparency. So the new rules allow for increased transparency in the process, here, in arbitration cases under the ICSID Convention, with respect to awards, they will continue to be published with the consent of the parties in the arbitration, as required by Article 62 of the ICSID Convention. And remember, the ICSID Convention was not amended. But what is new is that if the parties are silent, meaning that if they do not give consent to publication, but they also do not object to publication within 60 days, so if they're just silent for 60 days with respect to publication, then their consent to publication is deemed to have been given and the award is published. So, but if they object to publication, then the center will prepare extracts of the tribunal's legal reasoning, as used to be done under the 2006 rules. And that's for just awards in convention cases. With respect to decisions and procedural orders in convention cases, as well as awards, decisions, and orders in additional facility cases, those will be published. And they will be published with redactions agreed by the parties, or if the parties don't agree, decided by the tribunal. In addition, a party can now publish its own main pleadings, but with redactions agreed with the other party, because to avoid that this rule be used to publish information or parts of pleadings from the other party that party does not wish published. Hearings are open now unless either party objects. And the difference between the 2022 and 2006 rules is that the tribunal under the 2006 rules may open hearings with the consent of the parties. Now, the tribunal shall open hearings unless the parties object. So the discretionary element is gone. Next slide, we have a brand new set of rules offering expedited arbitration. And that shows you the process. And the parties, an expedited arbitration applies both in ICSID cases and in additional facility cases. And the parties can consent to apply the full set of rules to their case or apply parts of the rules, portions of the rules to their case. But if the whole set is applied to a case, it is meant to reduce the time that a case takes by half, so 50% which is a sizable reduction. And this rule could be particularly interesting for parties that are conscious about duration and costs, and also relevant for states that seek to promote foreign investment by SMEs. Now, I have been discussing changes to the arbitration rules under the ICSID Convention and under the additional facility. Now, I just want to take one slide to look at the additional facility on its own and tell you what has changed there. Because for the most part, the arbitration rules under the two mechanisms are very similar. But the real change here with the additional facility is with respect to its jurisdictional reach. And in particular, the way in which it has been greatly broadened. So under the 2006 rules, cases that go under the additional facility were cases where, number one, that arise directly out of an investment, but either the state party to the case or the state whose national is a party to the case are not is not an ICSID member state. So one of these states is not an ICSID member state, but the dispute relates to an investment. So that's scenario number one. Scenario number two would be a case that does not directly arise out of an investment, but either the state party to the dispute is an ICSID member state, or the state whose national is a party to the dispute is an ICSID member state. So that's scenario number two. And scenario number three for application of the additional facility under the 2006 rules were for fact-finding, which have now been moved to their own set of rules. Now, the way in which this rule has changed in the 2022 rules is that additional facility cases can now involve parties where the state party to the dispute is not an ICSID member state, and the state whose national is a party to the dispute is not an ICSID member state. So there's no longer, there's no longer a requirement for ICSID membership or a link to ICSID for either of these states. And that's one way it was broadened. Another way in which it was broadened is that an REIO, a regional economic integration organization, can now be a claimant or a respondent in an additional facility case based on its consent. And the third way is that the requirement for approval of access to the additional facility has been eliminated. Moving on to fact-finding. The fact-finding rules, like I said, have been updated, and fact-finding must relate to an investment, but the access has been broadened. So REIOs can now, or any state can be a party to a fact-finding. And under these rules, the parties can jointly request that a fact-finding committee establish a protocol, a procedural protocol. Establish a procedural protocol to make specific fact-findings in the dispute. And why have this? It's designed to respond to a perceived need to put more emphasis in preventive mechanisms. And so the idea, so at the pre-litigation stage. So the idea then is to have an impartial assessment of the facts in order to avoid escalation to a legal dispute. Lastly then, the mediation rules, which are completely new. There is, of course, increased interest in mediation in the treaties and also in the regional instruments, even in the African instruments. I can cite the investment protocol of the AFCFTA. This falls also, offering mediation, falls in line with the objectives of the Center to offer a broader range of dispute settlement options to parties. These rules are also available to any state or any REIO. There is no requirement of a membership link by a state to ICSID. Mediation, the rules are also very flexible. So mediation can be commenced at any time based on consent of the parties. And even so at the pre-litigation stage, before arbitration is commenced, or they can be commenced while arbitration is ongoing. And they can be based on an existing agreement, so prior to a dispute arising. Or they can be based on an ad hoc agreement, so after a dispute has arisen, the parties can consent to mediation. Because it's consent-driven, continuous consent, the parties, either party, can withdraw from the mediation at any time. And the rules have also been set to align with the formal requirements of the Singapore Convention for enforcement of settlement agreements. I think that among the 13 now, African states that have signed the Singapore Convention, none have ratified it yet. So I will stop there. I have so this is the process of mediation. It's a fairly simple process. I will stop there. I didn't say anything about conciliation. I do have a last slide on conciliation, if you can just show it. And I will just say that the conciliation rules under the ICSID Convention and under the additional facility have also been amended and updated. And a lot of the time when you talk about conciliation and mediation, sometimes the question arises, what's the difference? So this slide is just meant to sort of show the differences between conciliation and mediation. And I think they will be circulated, they'll be made available, so I'm not gonna read them for you. All right, thank you so much.
Thank you very much, Aissatou. Thank you very much. We've not lost any time because this panel is all about ICSID rules and regulations, and your detailed information was excellent. Thank you. So, well, the next speaker, I'm going to make the questions more direct and easy to answer and short, because in the interest of time that we have remained with. Randi? How will the key changes that we've just seen highlighted affect the investor-state dispute settlement? And very quickly, I note that the ICSID rules and regulations are provisions aimed at time and cost, right? Time and cost. Do you think the African states, these amendments are going to attract more interest for the African states to go to ICSID for their dispute settlement? Thank you. Much, Aissatou. Thank you very much. We've not lost any time because this panel is all about ICSID rules and regulations, and your detailed information was excellent. Thank you. So, well, the next speaker, I'm going to make the questions more direct and easy to answer and short, because in the interest of time that we have remained with. Randi? How will the key changes that we've just seen highlighted affect the investor-state dispute settlement? And very quickly, I note that the ICSID rules and regulations are provisions aimed at time and cost, right? Time and cost. Do you think the African states, these amendments are going to attract more interest for the African states to go to ICSID for their dispute settlement? Thank you.
Thank you very much, John, for the kind introduction at the beginning, and allow me just to thank the organizers for inviting me today and inviting me to Kigali. It's also my first time here, and I would like to thank the Secretary General of KIAC for inviting me specifically, and I'm really honored and happy to be here among all the panelists and the speakers. So back to the question, how will these key changes affect investment, state dispute settlement, and it's commonly referred to, for those who are not familiar with the system, as ISDS, so I'll commonly refer to the system as ISDS. So as you can see from Aissatou's presentation, that this has been a much awaited revision by all practitioners and all stakeholders involved in ISDS, and they all participated in the process in a way or another, and the process has been followed very closely throughout the 5 years that it took to come to life. So this has been the most comprehensive round of amendments today. As Aissatou said, it went through 4 rounds of amendments, and this is the most comprehensive, and it introduces structural changes, stylistic changes, and also substantive changes. And given that ICSID is the leading institution that administers ISDS cases, and to date, we estimate that it administers approximately 70% of all known ISDS cases. So that alone could give you an idea about the scale and the extent of the impact of ICSID proceedings on ISDS as a system in general. And more specifically on how these key changes will affect ISDS, and I think the first and foremost were the changes or the amendments were there also to address some of the criticism that has been addressed to the ISDS system, the so-called legitimacy crisis of the ISDS system. And I will just limit it for the interest of time to a couple of points. So the first one, and I think one that has garnered a lot of interest, is transparency. So we will see, you saw in Aissatou's presentation how enhanced the transparency will become under the ICSID convention arbitration or convention proceedings, and also the additional facility proceedings. So that alone will, so you see, we saw that will be orders, the rulings, the decisions will be out there, will be published either with redaction or not, depending on the parties' agreement. A lot of hearings will be public, and the awards, so we will have a lot of material that will be out there in the public domain, and that alone could be a great educational tool for the entire system and for outsiders as well. And the main also goal is to restore and rebuild trust in the ISDS system and address this legitimacy crisis, because some perceive it as a closed and obscure system. So that's the first thing that we should see, and how it should affect the ISDS in general. That could also help have more consistency and coherence by having a lot of transparency and having a lot of publications. That should enhance also the consistency and the coherence in the system. And for those parties who would like to have more coherence, also the rules, wow, that's very transparent. The rules also provide for voluntary consolidation and coordination. So that should also limit the parallel proceedings, and that will also touches upon your point about the time and cost efficiency. And that will lead me to the second point, that the major also criticism is the time and cost efficiency of the ISDS system. The microphone is, sorry. So the time and cost efficiency of the ISDS system. So the second thing is that, as also Aissatou referred to, we will have much shorter time frames for proceedings and shorter timelines. We should expect to have more proactive tribunals. They have the obligation to conduct the to conduct the proceeding in good faith and an efficient and cost-effective way, they have obligation to have more case management conferences in which they try to narrow down all the issues that discussed in the proceeding and in the dispute. And they also, and most importantly, they have fixed deadlines for tribunals to hand down any ruling and awards, because handing down the ruling, the award was one of the phases that that consumed a lot of time in the proceeding. So now it has a very limited time. The last point I will address here is the new actors. So one of the new novelties of the amendments is the introduction of the expedited. So one of the novelties is having a chapter on expedited arbitration, and that means that we'll have much shorter, it's a set of rules to have much shorter framework for low-value claims, and we should expect having new actors and new participants in this, and especially small and medium enterprises. So we'll expect to see new disputing parties. So it's not only for multinational corporations, and now we will see more SMEs. And the last thing is also new actors, thanks to the expansion of the scope of the additional facility. So we expect to see more REIOs, the Regional Economic Integration Organizations, as disputing parties. And we also expect to see non-ICSID parties, because now they can have investor and states that are not ICSID bodies. So these are the these are how the key changes would affect the ISDS, and I think the more interesting point is how, or if this will increase the African states' interest in ICSID arbitration. So the short answer is I think it's absolutely yes. And I'll try to prove that with some numbers, even though this is not my strongest point. But so the African states were very much involved in the process of amendment from the very beginning. They sent the written comments, they attended the consultations, they voiced their concerns, and they made proposals, so they were not shy about what they wanted to see in the rules. And as Aissatou said, 85% voted for the amendments. And if you calculate it, you have, as of today, you have 47 African states that are member states of ICSID out of 158 member states. So that's more or less a third of the states at ICSID are African states. And the 5 missing, 3 of them are also signatories, so they're also participating in the system in a way or another. And that's not a new thing for African states to be active in the system, because if you go back to the creation of ICSID, we needed 20 ratifications in order for the convention to enter into force, and 15 out of the 20 were African states. So thanks to African states, the convention came into force. As to the proceedings, the ICSID proceedings, you could see that around 20% more or less are proceedings involving African states. So that's also a significant number, and you can see that there is a participation by African states in ICSID. And I will just give a few also other points about the active participation of African states, and especially when it comes to new things, and they are really pioneers on so many levels. So as you know, or as also Aissatou mentioned, that at the ICSID system, a state could also be a claimant. And to my knowledge, the 2 times that we had the state as a claimant, it was an additional facility conciliation case, and that was brought by an African state, and it was Equatorial Guinea. And the participation, well, and here I refer to my country, Egypt. So Egypt is the most sued African country before ICSID, and is one of the top 5 most sued countries overall before ICSID. So a lot of participation by Egyptians in the system. But that also, as also was discussed yesterday, that's also an educational tool for African states. So at the end of all of this, all I want to say from that African states have already had a lot of interest in the proceedings and in ICSID, so I don't see why that will not continue to be the case under the new rules.
Thank you, Randi. Just a quick one. I can see the time-bound handout of the ruling. What if it delays? Does it affect the arbitral fees, or do they get reduced? Or is there any kind of reprimand? Or?
If they didn't follow the obligations about the timelines, yes. So there is this new obligation that says that parties and arbitrators should conduct the proceeding in good faith and in a cost and time efficient manner. So this is an obligation. And then there is also now a chapter on costs. And in this, the arbitrators have also now the discretion to give reasons so the arbitrators could take into account whatever happened if a party tried to tactically to delay or not respect any of the obligations, then the arbitrator could take that into account when they allocate the costs, because now they don't have to allocate it in accordance with the cost follow the event. So they can take the conduct of the parties into account in that respect. And also for arbitrators, the obligations for arbitrators to respect a specific timeline, they also they have to do so, and unless they have valid justification and reasons, and they have to explain to the parties why they will not be able to render a decision at a certain time. And in my understanding as well is that paying the arbitrators could be postponed until they comply with the timelines and complies with the rules. So I don't know if that answers the question.
Yes, it does.
Yeah.
Thank you very much. Finally, I think let me give a chance to my colleague, Bâtonnier Julien, to give us the Rwandan context before we go to the audience. After all, we can get more informed about the rules. We only have 4 colors: blue, red, yellow, and green. So you can find all the information on the website. Bâtonnier, what legal institutional framework is there in place for the ICSID rules and regulations in Rwanda? And if to give it context and in the concept of time, Rwanda is a party to the ICSID Convention. Considering that, what are the roles of the courts today? If there is any, how receptive are they? Just give us some context so that at least we may bring our own country into the ICSID rules context in today's discussion. Thank you.
Okay. Thank you, moderator. Having lawyers in the room, I have to be precise, so I've been checking on the website and verifying with the legislation in Rwanda. So it's a decree of 1979 that has been ratifying that treaty and allowing Rwanda to be a member, and it has been into force since 14 November 79. So it's really old, but still valid. And Rwanda has been designating the Tribunal de Grande Instance to be the one enforcing, if in any case, whatever decision that can come up But the good news is that, and I think what is specific with ICSID, is that each and every country member and signing and ratifying the treaty has the obligation to ratify awards coming from ICSID, which make it mandatory for each and every member, not only the one winning or where the decision was supposed to be enforced. It means that each and every member become a partner in the enforcement measure. So that is a big specific advantage for that arbitration award, because if you have, let's say, a problem with Egypt, and there is an asset that can be seized in Rwanda, you can use the ICSID, and that Rwanda is a member that has been ratifying that decision to be able to be the one enforcing an award against Egypt in Rwanda. So without going necessarily to go to Egypt or to go to another jurisdiction. So each and every 158 now with Angola will be a partner in the enforcement. So if you cannot be able to enforce in Rwanda, in Egypt, you can maybe go in another jurisdiction where there is asset to seize, or where there is a bank account that you can use to get your money back. So enforcement and court intervention, domestic court intervention, is needed, because at the end you need court to be able to seize an asset or a bank account or get your money back. You need a partner on the local side, on the national side, but they are not usually challenging that award, specifically for Rwanda. And I have the privilege to have the Chief Justice Emeritus in the room, who has been pro-arbitration for many years, and allowing even KIAC and other award through the New York Convention or an ICSID jurisdiction, that court are partners, not competitors of arbitration. So having a domestic court pro-arbitration and pro-enforcement of an award is usually a good practice and a partner. So it's not competition, it's complement. They are complementing each other. So that is, especially in Rwanda. So that is my comment on that. I hope it's answering your question.
Thank you very much. It's interesting that all my questions have been preempted by the speakers. So over to you, the audience. If you have any questions that, there you were, Emilia. Okay, there's none. Any of you could take on that? The new code of conduct and where we are?
So do you hear me if I speak in this microphone? Yeah. Okay, so on the code of conduct, so that's actually part of the ISDS reform efforts, and this addresses the point of the impartiality and independence of arbitrators. So for the code of conduct, now we have the fourth version of the code that went out, and we're expecting a fifth one soon. And that was effort between ICSID and UNCITRAL. So the code, it has all the new obligations for the arbitrator, and it addresses the question specifically of the double hatting. They call it limitation on multiple roles, and it addresses the disclosure requirements, and indirectly addresses repeat appointments, and also issue conflict. So it should address all the questions that are raised regarding ethics of arbitrators in ISDS, and it will apply, most of the provisions apply to ad hoc arbitrators, but some of the provisions are also applicable to judges for the EU kind of standing body. But I mean, I can be more specific if you want to, if you have a targeted provision that you want to speak about.
If there are no more questions, Divine, anybody in the audience with? There you are.
Hi, Alexandre Wagan. I'm from Jus Mundi. Thank you very much for your presentation and the amazing work that has been done in the revision of the ICSID rules. It will come with no surprise that I'm interested in the transparency part of the revision of the rules. And it's really just a clarification and a question that I really have, that I'm not sure I have understand. I understand that there is a differentiation in regime between convention award and additional facility awards and procedural orders. So first question really to understand is why do we have this different treatment according for transparency? Or don't we have the same reason militating for transparency and the same reason for additional facilities, materials and convention materials? And the other part is a more technical one. I understand you mentioned that, well, I'm not sure I understood exactly the way the redaction process will take place. It's an order from the tribunal or the party must agree before. So it's just a clarification on what you say, because obviously I'm very interested on those aspects. Thank you very much.
I can take the first question about the defense convention and
Thank you, Alexandre, for that question. So there is a differentiation in regime between ICSID awards falling under the convention on the one hand, and then orders, procedural orders and decisions falling under the convention, as well as anything issued under the additional facility. So that's where that division is, first of all. Now, the division is there because I said that the convention is not amended. And there is an article in the convention which says that awards, the wording is awards, cannot be published without the consent of the parties. And that's where, so that kind of boxes in awards issued under the convention in a way that it does not box in anything else that is a decision or procedural order issued under the convention or under a different mechanism than the convention. So that's why we have that distinction. And so the way, though, we have still managed to create more transparency for awards, even though they're kind of boxed in by the convention, is to have this new provision in the 2022 rules, which deems consent after a certain period passes and the parties are completely silent as to whether they give consent or not, whether they object to publication. So they can still, they still have the advantage of objecting to publication. If they want to have the award be confidential, they have that option by expressing their objection to publication within a period of time. After that, then consent is deemed and the award will be published with any redactions that the parties wish to add. And I want to say that, there are a lot of old awards where, we have tried to reach out to states to get their consent to publication. We don't get any responses back, and we have tried to reach the claimants in those cases. Sometimes they no longer exist. We have tried to go through the route of their counsel. I'm talking about cases issued in the 1980s, and it's unfortunate that these cases are just completely out of reach in terms of publication. And so this deeming provision is then geared to also kind of avoid that for future cases or going forward. So that's, and I forgot your second question. The redaction.
Isaac, your last question. Yours is the last.
So he has the second question.
Okay, there's the second question.
Is the redaction. And your question is with respect to the process, how it works, right? So let's say for any award or for decisions or procedural orders, when it is to be published, the parties have a right under the rules to propose redactions, right? And so, of course, you can say that, well, a party can just redact the whole document, but you have two parties, right, in this proceeding. So if such is to happen, likely you'll get an objection from the other party. And as long as you have disagreement between the parties, then there is a process of redaction whereby the disputed portions of the redactions are given to the tribunal for decision. And so the tribunal makes the ultimate decision as to what is appropriately redacted and what is not. And I will add to that that we also have, under the chapter on transparency, we have provisions for the protection of confidential information, and we have a number of subparagraphs providing for the types of confidential information that would also be protected and would be redacted as well.
My questions just relates, if you could help me to give me the rationale of this accountability that basically leads to the publication of the award. Dr. Randi mentioned that in Africa, Egypt is the most sued and the suing party. And these disputes, mostly investment-related disputes. Don't you think that this so-called accountability that leads to publication of the award, some in the other way affects the party, some parties, by discouraging investors to come and invest in that country? To whom is the ICSID accountable to the extent that it always has to publish the award, unless the parties decide not to have the award published? That is my question. What is the rationale of publishing the awards?
The rationale for publication, why have it published?
Yes. My understanding of arbitration basically is one of the core elements of arbitration is confidentiality.
Mm-hmm. Okay.
And my question is, the publication basically overrides that principle of confidentiality.
Right.
And I'm finding a damage that results from this publication. If Egypt is the most sued, or sues, a country, doesn't that, if those awards where Egypt has been much involved, if they are published, don't they discourage investors to go to Egypt?
So I'll let you, perhaps you want to answer the question. I just want to, this is a very small clarification. There is a difference between the fact that a proceeding exists at ICSID. That's public information. And ICSID has an obligation to publish that in its registers. And now the registers used to be these books that were handwritten. Now they're online. So there's a difference between the fact that there is a case between ex-claimant and Egypt, or ex-claimant and Senegal, and the award that's issued and the contents of that award. So the transparency debate is about the award itself, not the so whether the award is published or not, the fact that Egypt is being sued by ex-claimant of Y nationality is still going to be public knowledge. You see what I mean? So I will let you, though, if you want to.
Yeah, if I understood the question correctly, it's the rationale about publishing the awards in investment arbitration. So the first thing, I think, is the distinction between investment arbitration and commercial arbitration. The commercial arbitration is widely known to be very confidential, but investor-state dispute settlement, given that it involves a state, so there is the public, sovereign, and public interest that are involved in investment disputes. So given this involvement, there is this publication of transparency to hold the country accountable. So this is one, or the big difference why it's not entirely confidential in investment arbitration. But in the convention, yes, they can object to publishing the award. But under the new rules, even though it's an enhanced transparency, they still have veto votes to block opening the hearing to the public. They still can have redaction of all confidential information. And there is a provision about what could be qualified as confidential. And so it's the rules still give flexibility and control to the parties and also to the states for them to decide in their instrument of consent what they want in their treaties or in the laws, what they want to see or what they want to have in a specific proceeding, if they want to close it or if they want to open it to the public or if they want to publish or not. So about discouraging the investors, from my point of view, I don't see why that would discourage the investor from using the system, if I understood this question correctly. Yes, they will see that Egypt is sued and has been sued so many times by investors, but from my point of view, is that investors want to publish the awards and want to see what happened instead of only seeing the numbers of proceedings that Egypt has been involved in, but also to see the content and what happened in a specific situation. So this is how I understood the question, but I'm glad to elaborate more on a side note.
No, you understood it well, and yes. So being a Friday and the last day of the conference, I would very much want to register my special thanks to the audience for being very early, attentive, and responsive with our panel. And with that, I would like to also ask you to join me and thank the panelists. Thank you, and have a very good morning.